page 20, page 21, page 22, page 21, yes.
Thank you, Speaker. Page 21, Roman numeral XIII. The word regional coordinator, I think coordinator is wrongly spelled. Thank you.
Yes, Honorable Member, you are right. Table office kindly take note. Also take note of the earlier corrections he made in respect of page 15, I think. Please. In respect of page 14. Yes, we now move to page 20, page 21, 22, page 23, page 24, 25, page 26, page 27, page 28, page 29. Yes, page 29.
The Speaker, with respect, the Roast Minister is here. On his CV and also on the records I know, is governs Kwame Abuja. I noticed under 3I that the governs has been omitted. It's only Kwame Abuja. Mr. Speaker, so if that correction.
I got some intervention from the clerk.
Mr. Speaker, I don't know your mood this afternoon. I wanted to say something, but I want to be sure of your mood first. But I'm not too sure. Mr. Speaker, we have to be careful about your mood before we say anything. But with this broad smile, I think I may go ahead. Mr. Speaker, Kwame Abuja, look at his posture, the way he's seated. You know, Mr. Speaker, the man, his releases, he has not received them. Then he can't talk. The contractors are on him. He can't pay them. He can't talk. He has even lost weight. He has lost weight. Yes. Mr. Speaker, he still doesn't have his 2025 releases.
Minority Leader is part of the correction of proceedings.
Mr. Speaker, his name. Mr. Speaker, I am saying so because his own name.
Yes.
His own name is supposed to be governs Kwame Abuja. He's seated right here. And Mr. Speaker, the man is thinking, but it's okay. I've corrected it for him. He's my friend.
Yes, Honorable Minister.
Mr. Speaker, my first name is Kwame. My middle name is Governs. So there's nothing wrong. I'm popularly called Kwame Abuja. So there's nothing wrong with it.
He has succeeded in putting it on the record that you haven't paid contractors. That's all what he wants to do. So we may go to, I said you have succeeded in doing so. So we can move now to page 30. Page 31. Page 32. Sorry, page 31.
Thank you, Mr. Speaker. Thank you very much. Page 31, XVI. The aid to the minister is Jude Agbemava, not Agbemavo. So O should be deleted and replaced with A. Then again, Speaker, XXVI. The department is Feeder Road, not Federal. So if that could be captured rightly and then corrected consequentially. Thank you.
Yes, Honorable Member, you are correct with the feeder. The other one, I don't know. So the class will cross-check to get the correct spelling of the name Agbemava. Please, table office kindly take note. Yes, Minority Leader.
Mr. Speaker, I seek your guidance on XVI and XVII at page 31. Mr. Speaker, XVI reads Mr. Jude Agbemavo, aid to the Minister, Ministry of Roads and Highways. XVII, Mr. Salifo Abdul Rahid, personal assistant to Minister, Ministry of Roads and Highways. Mr. Speaker.
What is the issue?
Yeah, Mr. Speaker, that's why I'm seeking your guidance. There we have aid to the minister and then personal assistant. I thought there was some mistake since the minister is here.
Well, these are not strange to me. The time you were in office, the same renditions were all over the place. So what is wrong with that?
Well, Mr. Speaker, because of the lean government situation.
Because of the reset.
Yes.
Okay.
Mr. Speaker, because of the lean government, they said few appointees. But even the minister alone is now having an aide and a personal assistant. That's why I just wanted clarification.
I can assure you the Speaker is counting the numbers. And
Very
the Speaker will lead you to hold them accountable when the numbers go beyond your numbers or even at par with
Mr. Speaker.
It will not be.
Mr. Speaker.
It will not be
Mr. Speaker.
It will not be
Mr.
a lean
Speaker,
government.
you want
I will
to
lead you.
Mr.
Don't
Speaker.
worry.
Mr. Speaker. You want
Mr.
to.
Speaker is very
Mr.
fair.
Speaker, you want to start a debate.
Mr. Speaker is very impartial.
Mr. Speaker, you want to start a debate. Leave this for us. Mr. Speaker, if you say it goes beyond our numbers, they are in government. They say reset. How can you have an aide
So I'm
and
going
a
to
personal
hold
assistant?
them. I'll hold them accountable.
Yeah, Mr. Speaker, you should answer to this. You have an aide, you have a personal assistant. If you go on to the list, there are many appointees. By you alone?
Yes, Majority Leader.
Mr. Speaker, I think it is important to make sure that the records are properly captured. So, Speaker, a minister is invited to a committee sitting. He is often accompanied by staff of the ministry. Staff of the ministry. Staff of the ministry. Now, if a staff of the ministry at the committee sitting introduces himself as an aide to the ministry and the committee chairperson captures it, it is not the same as the past practice where special assistants and aides and deputy special assistants were appointed as presidential staffers and posted to ministries to serve as special aides to ministers. Mr. Speaker, this is not the case. In this case, a staff of the ministry accompanied the minister to a committee meeting, and the minister doesn't know the person as a special aide, and I can testify to that, and the minister is sitting here. So I don't want it to be misrepresented that this government that has committed to being lean is appointing presidential staffers and sending them to ministers as special aides. So, Mr. Speaker, as a matter of record, the minister doesn't have a special aide. I just want it captured. As a matter of record, this government remains lean, this government will be lean, and this government is committed to being lean. Thank you, Mr. Speaker.
Honorable members, this is not open to debate. The record states clearly that aid to the minister, and the minister did not correct it. And so he's just drawing attention to it. If the person is not aid to the minister will correct and says, no, this person is not aid to me. Then we get the records rectified. Again, honorable members, I know the difference between deputy speakers and leaders of the House. So you realize your new standing orders have shown precedence. Deputy speakers are constitutional appointees. Leaders of the House are appointees on the rules of practice of the House and anchored by a statute. So I know the difference between appointees from the President's office posted to ministries and appointees by ministers. Are not of the same sizes. So don't worry at all. We will, sorry? Ministers of what?
Mr. Speaker, just some clarity. I doubt if ministers on their own can make appointments. They work with civil servants. And so everybody who is at the ministry is a civil servant.
Yes. They are not all civil servants. Some are public servants. There is a difference between public servants and civil servants. There is nothing that bars a minister through the due process of either the board, ministerial board, to appoint somebody at the ministry's level. And the president, as you know by constitution, almost appoints everybody, apart from a few of us that the president cannot appoint. So that difference is there. Yes, minority leader.
Mr. Speaker, with respect, just for purpose of our records, you explain the difference between a civil servant who is part of the mainstream civil service and an appointee of the minister who is assisting the minister. May we, just for clarity, the Jude Agbemavo, the aide to the minister, and Mr. Salifu Abdul Rashid, personal assistant to the minister, Ministry of Roads and Highways. Since the minister is here, and then earlier the majority leader has spoken on this matter, is it the case that these two individuals are your appointees or they are officers of the Ministry of Roads and Highways that you are relying on to assist you, just for the records? Because we have to check this. We will check. Yes.
Mr. Speaker, the respected minority leader do all the checks he likes. And I'm happy to do that, assist you in that. Mr. Speaker, I do not have any official with me at the ministry that draws salary or anything, as a matter of fact. Mr. Speaker, nobody. Listen, I'm coming there. I'm coming there. As a record, Mr. Speaker, I don't have even an official vehicle. I don't have official residence. I'm telling you, those ones that, Mr. Speaker, don't keep quiet. Those, hold on. Listen. You've asked the question, let me answer the question. Mr. Speaker, those are things I am entitled to, but I'm saying I do not have an official vehicle. I do not have an official residence. I continue to use whatever I have as a member of Parliament. Mr. Speaker, this meeting, this report is about the Committee of Parliament, a Committee of Parliament paying a visit to the ministry. The long list of individuals recorded here, I have no knowledge of their identities. This is a record of Parliament. So if you, of course, I mean, we have a long list of directors of other things. So if you ask me who is my this thing, I have an individual, Jude Agbemava, who actually works with me in Parliament. So maybe in your, when you were serving, in fact, I saw, Mr. Speaker, when your government was in power, I saw you being guarded by military people. When you were not minister of, yes, I saw military people guarding you. When you were not a minister of defense and other thing. I can guarantee you, President Muhammad's government does not allow things like that.
Please.
And let me repeat,
there's
nobody at the Ministry of Roads and Highways
who is
an official have carried upon who draws a penny from the public purse. Jude is my PA in Parliament, and he's with me. That's all. The other designation here as I have absolutely no knowledge who that individual is. That is a fact. I don't know that individual.
Yes, honorable members, he clarified saying that he has an aide in Parliament here, who is the aide that is called Jude Agbemava. But the person called personal assistant to the minister by name Salifu Abdul Rahid, he has no knowledge of that person. So those who say you are going to investigate, you may proceed to do so. And let us know whether your suspicion is correct or what he is stated now is what prevails in the ministry. We move on to page 32, page 33, page 34. Honorable members, in the absence of any further corrections, the votes and proceedings of Thursday, 5th June 2025 is hereby adopted as the true record of proceedings. I don't have any copy of the official report. I'm told the last one was a few weeks ago. May I, with your kind permission, acknowledge the presence of a number of visitors who are at the visitors gallery to observe proceedings of the House today. We have students from the Medina MA4 Junior High School, led by the head teacher in the name of Josephine Adu Techi. They are 60 in number. That's quite a large number. And the constituency they come from is La, in Kwantanang, Medina. La. The name is La, it's not Labadi. So those of you who have been misled by the colonial masters, it's La, not Labadi. La in Kwantanang, Medina. The name Legon is not Legon, it's Lagono. Lagono. Please, you are welcome, and I hope that you learn something from what you are observing. Please, Madam, congratulations for leading them here. We have a second group. You may resume your seats. We have a second group from St. Francis Senior High Technical School, led by the Assistant Headmaster, Domestic, by name Mr. David Jasper Boateng. They are 68 in number, and they also come from the constituency called Achim Oda. Please, you are also welcome. and we appreciate the distance from which you came. We encourage you to come more often because we want you to grow and perform better than we are doing. Thank you so much for coming. You may resume your seats. Now, honorable members, the next item is urgent questions. Urgent questions. I will call on the First Deputy Speaker to take the chair because I have some guests making courtesy call on me. So we can start with the urgent questions. And I want to start from 7A. 7A. Mr. Patrick Yao Buama, Okankwe Central. You may ask your question now. Sorry, Majority Leader, is there any issue? Sorry, just hold on, honorable member.
Yes, Mr. Speaker. I think the clerks at table confided in me that they are having difficulty reaching the Minister for Foreign Affairs. But, Mr. Speaker, that is understandable. That is understandable. He is the Minister for Foreign Affairs. He is the Minister for Foreign Affairs. He is the Minister for Foreign Affairs. Mr. Speaker, in the case of the Minister for Foreign Affairs, we need to always be sure that he's in the jurisdiction before we schedule him to answer questions. And so, Mr. Speaker, I am equally unable to reach him to confirm his availability to answer the questions. So, Speaker, this is unfortunate, but it is understandable because it is the Minister for Foreign Affairs. And I don't know even if he's within the jurisdiction or out of the jurisdiction. And in some jurisdictions, such as China and faraway places, it will be difficult for your phone to work. So, Speaker, I plead that this House do consider rescheduling the questions for the minister. This is a minister who we know in his previous life, when he was not a minister, was very, very actively participating in this House. And even as minister, when he's within the jurisdiction, he makes himself available. So I plead with the honorable member that we reschedule the minister to come and answer the question at a future date when he is within the jurisdiction.
Yes, Minority Chief Whip.
Speaker, Majority Leader's call for us to reschedule the questions advertised in the name of the Foreign Minister as urgent question. It's not difficult. We can easily accede. As supportive as we have always been, you have always called on us to stage compromises for you to prosecute government business, which we have often obliged. However, I'm taken aback because these questions were advertised in the business statement that was adopted by this House. So your defense of not reaching the Foreign Minister is not tenable. Last Friday, we adopted the business statement. And are you telling me that from last Friday up to now, why is the Foreign Minister gone to the moon? Is he gone to the moon? Last Friday up to now, you can't reach him. What kind of network is he using?
It's actually a repeated question. It's a repeated question.
Majority Leader, what kind of network is the Foreign Minister using that you can't reach him? I find it strange. And Speaker, more to the point, more to the point, I don't know what your defense will be. The Minister for Fisheries and the Minister for Transport were scheduled to also appear today. Where are they? You can't also reach them. Is that the case? And you can so moto decide to take off the question without recourse to us. Because the questions are compounding, and we have a backlog of questions. And your request, we can accede to your request. But what is going to happen to the backlog of questions? This will go and add on to the backlog. And that's what created the problem for us. This is the tool that members have to elicit response from ministers. The ministers will not show up. What has been the practice in this house? If ministers can't show up, they need to show respect to this house. Honorable Blackwell knows what to do. He should have at least written to this house. And you suddenly rise up and say that you can't reach the minister. I'm asking you, majority leader, what network is the minister using? Is it MTN or Vodafone or what have you? Because this will not be acceptable to this house. This will not be acceptable. He should get the foreign minister to appear. At least we have some time. We just started sitting. Go out there, make your course, and get the foreign minister to appear before this house. This, we on this side will not accept your reason. It's lame, it's not tenable. Besides the point, the transport minister is equally not here. The minister for fisheries is not here. Maybe a Blackwell we can understand, but the ministers who have deputies, they just write. And a trend is emerging. Some of the ministers, they just write, and that's it. They're just abusing the process. I don't want to mention names, but I see senior people here. The road minister is always here. The road minister is always, even though my road is not done, he's always here. Why are the other ministers not taking the cue from the road minister? I don't know what colleagues think, but this is not tenable. And the majority leader should tell us something better. You can't reach him on phone. The clerks at table also can't reach him. The foreign minister will not write to us. Has he written? Chief Whip, we have to empower you. They have to report through you. When we were here, that was what we were doing. Take a cue from us. The ministers must report to the Chief Whip, and the Chief Whip will report to the leader of the government business. They won't tell you anything. You are the majority Chief Whip. The minister should route their difficulties through you, and then you will run with us. You are not even aware. Chief Whip, you are not aware. Speaker, so this is not right. You cannot take this house for granted. You can't take this house for granted. Find the foreign minister. Get him now. No. We need a black one in the house right now. Get him.
Honourable members, do we need to debate this matter?
Mr. Speaker,
Minister for Rules, yes?
Yes, on record, our colleague, Honourable Blackwell, is one of the very diligent members of this House. Mr. Speaker, he is currently out of the jurisdiction on official engagement. And, Mr. Speaker, he was scheduled to be back by now, but something held him up. So I am sure he will do the needful and make himself available as soon as he gets back to the country. So, Mr. Speaker, he did not basically ignore the call from members. Honorable Ablakwa will be here when he returns to respond to the questions of colleagues. So just to put on record, he did not basically just ignore his return was delayed for reasons beyond his control. Mr. Speaker, thank you for the opportunity.
Honourable members, I'm actually not persuaded by your submissions because the honourable member who is now additionally the Minister for Foreign Affairs is aware of the rules of the House. And when there are even emergent situations, it's very clear in his mind the procedure to follow. The other ministers are not here because they have already indicated through the correct process to the clerk and my good self that for good reason they will not be able to appear before the House today to answer the questions. And so I called on the clerk to take off the questions for today and to reschedule them in discussion with the business committee and the ministers concerned. But with regard to the Honorable Minister for Foreign Affairs, you can see the struggle the majority leader made in trying to put in some defense, which was very feeble. That is why he couldn't even say what the Minister for Roads and Highways have said. So we will not take that. It's important that this House be respected, and that is why in our rules, I can issue a summons for any person to be brought before the House by order. Failure to appear before the House, I can issue a warrant of arrest. And they are there in the standing orders. Our people may not know that we have these powers. And is there warrant of arrest is in compliance with Standing Order 134. Members, you may read it. It says where a person fails to A, appear before the House or a committee as ordered by the House or the committee, or B, produce a document as ordered, except where the production of the document is exempt by law, the Speaker may issue a warrant as provided in the safe schedule for the arrest of the person, and the person shall be brought before the House or the committee. And 2, the warrant shall be executed by a police officer not below the rank of Assistant Superintendent of Police. Let it be known by all that we have these powers, and we will execute them. Please. And 3 says, where the person arrested cannot be brought before the House or the committee immediately, the Speaker shall endorse the warrant with a direction that the person arrested be released if the person enters into a recognizance, as may be stated in the endorsement before a judge, a district magistrate, or the commander of the Parliamentary Protection Unit of the Ghana Police Service. These are all part of our standing orders. It's important we make this known to the public and particularly to our colleagues in the executive and the judiciary. We can do that. It's only that because we are father or fathers of democracy, sometimes we decide to at least be paternal and treat people with its gloves. But we have the power and authority to do more than that. So please, the minister will have to come and explain to us why he's not be able to show up for today. In his absence, we cannot have the answer. But we all know that the question is so important. And it's not something we can do without. And so I can only plead to the Honorable Member of Parliament for us to, in consultation with the Business Committee, reschedule the question soonest. And if what the Minister for Roads and Highways has stated is true, then the Minister for Foreign Affairs will be in the jurisdiction by today or latest tomorrow. Because you said that he should have been in the jurisdiction, but for some inexplicable reasons, he is not here. So it means that either he was on his way or he's just arrived, but he's not be able to move to the house. And so we can reschedule it immediately for him to come to respond to. But let me listen to the member who actually filed the question. Yes, please.
Thank you very much, Mr. Speaker. We definitely will comply with your directive, except to say that these questions were filed as far back as March, and it's been rescheduled a couple of times. Mr. Speaker, we all know the very important portfolio that the minister occupies. It's sad to say that to date, we don't have deputies assisting him and some other very important ministries. It's very important. If he had had a deputy minister, the deputy minister could have stepped in to respond to the questions, Mr. Speaker. Secondly, there are issues in Washington that we thought by now he should have been in Parliament to respond to. So we'll comply and respect your directive, Mr. Speaker, and ask that the leaders reschedule him as soon as possible to answer the question. I thank you very much, Mr. Speaker.
Yes, honorable members, please, the question will be rescheduled for the minister to come and respond to personally. So business committee kindly reschedule the question. Yes, Minister for Roads and Highways.
Mr. Speaker, just...
First Deputy Speaker, you may proceed now.
Just to clarify, my colleague, the foreign minister, is still out of the jurisdiction, so we will work with him to confirm his actual time of arrival to guide the rescheduling of the questions. Thank you, Mr. Speaker.
Thank you so much. I see the Attorney General and Minister for Justice. The First Deputy Speaker will now take the chair.
Yes, Honorable Majority Leader.
Mr. Speaker, the Minister for Justice is here. So if we can take his three questions numbered 32, 48, and then 120, Mr. Speaker. 32, 48, and then 120.
Honorable Minister. Honorable members, the Honorable Attorney General and Minister for Justice is here to respond to questions as indicated by the Majority Leader. So let's move to question number 32 at page 3 of the order paper. Standing in the name of Dr. Abdul Kabiru Tia Mahama, Member of Parliament for Wale Wale.
Mr. Speaker, Mr. Speaker, I have the authority from the Honorable Member for Walwale, and I want to seek your leave to ask the question on his behalf. Thank you.
Are you sure you have the authority?
Yes, Mr. Speaker.
When was the authority given you?
The authority was given to me today.
Today?
Yes, please.
So it means Honorable Member was in the House. Please proceed to ask the question.
Thank you so much, Mr. Speaker. Mr. Speaker, I rise to ask the Minister, the Attorney General, and Minister for Justice, the status of the prosecution of the armed robbery incident that occurred in Walwale on the 12th February 2024, and when the families of the deceased will get justice. Thank you, Mr. Speaker.
Yes, Honorable Minister, you have the floor.
Right Honorable Speaker, the question relates to the case of the Republic versus Zakaria Yamusa, aka Van Dam, and others. Mr. Speaker, the Office of the Attorney General in Tamale received the docket on the 25th day of March 2024, and the legal advice from the office was dispatched on the 10th of April 2024. Mr. Speaker, to give the background to the case, on the 12th of December 2024, at about 7 p.m., armed men attacked the victim, Rabiu Bilal, a mobile money vendor in Walwale with a gun and a cutlass, and robbed him of an unspecified amount of money. At the scene, the robbers fired indiscriminately, injuring 9 persons. The injured victims were identified as Alasan Sumaila, age 27, Mujahida Mohammed, age 6 years, Memunatu Isa, 58 years, Yakubu Idrisu, age 37 years, Richmond Afawa Dum, age 29 years, Azando Hana, age 24 years, Salamatu Inusa, age 20 years, and Abdul Mumin, age 25 years. They were all rushed to the Tamale Teaching Hospital and the Bolgatanga Regional Hospital for treatment. The victims, Rabiu Bilal and Sumaila Al-Hassan, died at the Tamale Teaching Hospital whilst on admission. On 17 February 2024, police investigations led to the arrest of the first and second accused persons while they were escaping to Kumasi on a bus. Upon police interrogations, both persons admitted to robbing Rabiu Bilal, the mobile money vendor, and mentioned third, fourth, and fifth accused persons as their accomplices. However, the third, fourth, and fifth accused persons, when questioned, denied any involvement in the robbery. The autopsy report of the deceased mobile money vendor revealed the cause of death as hemorrhagic shock secondary to polytrauma, whilst the cause of death of the other deceased person, Sumaila Al-Hassan, was stated as septic shock secondary to facial peritonitis from penetrating abdominal injury and multiple bowel injuries. After a careful study of the docket, the first and third accused persons were charged with conspiracy to commit robbery and robbery, contrary to sections 23(1) and 149 of the Criminal and Other Offences Act 1960, Act 29. In the case of the second, fourth, and fifth accused persons, no cogent evidence was established to prove their involvement in the robbery. Consequently, no charges were proffered against them. The first and second accused persons are in police custody. The accused persons appeared before the district court in Nalirgu for committal proceedings. The first accused person, however, pleaded the defense of alibi, and the magistrate directed the police to conduct further investigations. Upon a careful consideration of the alibi investigation report filed by the police on March 22nd, 2024, the Tamale office of the Attorney General's Department concluded that the defense of alibi raised by the first accused had no merit. This is because the first accused in his investigation caution statement voluntarily admitted to his involvement in the robbery. Hence, his defense of alibi was considered an afterthought. The primary cause of the delay in the prosecution of the case at the Tamale High Court was due to the plea of alibi raised by the first accused and then its related investigations. The matter was scheduled for case management conference on 27 February 2024 before the Tamale Commercial Court. It was previously before the High Court 1, Tamale. However, the case was reassigned to the Tamale Commercial Court 1 when the judge in the High Court was elevated to the Court of Appeal. Mr. Speaker, in terms of the current status of the case, the matter was to be prosecuted in Nalirgu. However, owing to the absence of the resident High Court judge for Nalirgu, the Nalirgu High Court at the time, the prosecution could not commence trial for the whole of 2024. In view of the gravity of the offense, a decision was taken to prosecute the case, the accused persons in Tamale. A charge sheet was filed in Tamale, and the case was assigned to Commercial Court, presided over by Mr. Justice Emmanuel Planche Brew. Unfortunately, the case management conference did not come off on the 27th of February 2025 due to the unavailability of the witnesses to sign their witness statements. Disclosures were filed by the prosecution on the 26th of March 2025, and the case management conference was conducted on 8th May 2025. The prosecution closed its case on the 26th of May 2025 after calling 3 witnesses. Counsel for the accused persons indicated his intention to make a submission of no case to answer. Hence, the judge ordered counsel to file his submissions on June 2nd, 2025, for the prosecution to respond a week after being served with the submissions. The prosecution is yet to be served with counsel's submissions. The matter has been adjourned to 16th June 2025. Mr. Speaker, that is the answer to the question number 32.
Thank you very much, Honorable Minister. Yes, Honorable, you have a supplementary question.
Mr. Speaker, I have no supplementary questions.
Very well.
Thank you.
Very well. Thank you very much. I thought this is a constituency-specific issue, but I will give you the floor. But make sure you operate within the rules.
That is so, Mr. Speaker, and I'm grounded under Order 89. Mr. Speaker, the update from the Minister, if you check the date of receipt of the docket at the AG's office, and then the legal advice dispatched as in 25th March 2024 and 10th April 2024, and the fact that he gave, I'm tempted to believe there's a disconnect, because according to him, the incident happened on the 12th of December 2024. And here we are talking about AG receiving a docket in March 2024 and legal advice 2024. So I want the Minister to first clarify the date as in these two.
Yes, Honorable Minister.
Mr. Speaker, I think the Honorable Member is right. There's a bit of a mix-up with the dates. I believe that in terms of the incident, it should be December 2023, so that in terms of the docket being received, it will have been March. So I can verify and make sure that that is corrected for the Hansard.
Honorable Minister, from the question, said the incident that occurred in Wale Wale on 12 February 2024. I think the date is in the question. So that was where the mix-up occurred. From the question, number 32, The indication was that the incidents occurred in Wale Wale on 12 February 2024. So I think that should be the right date. Thank you very much. Yes? Honourable Member, you don't have my leave to ask the second supplementary question.
Mr. Speaker, as I indicated, I come under Order 89.
So read the order.
Yes. Rule 3. He said any other member may be allowed to ask not more than 2 supplementary questions.
What is the meaning of may be allowed?
May you hear his interpretation, Mr. Speaker? It's a matter of right. May hear this. Once you allow me to ask 1, I'm entitled to 2 from the standing order. Yes.
That is not the meaning to be ascribed to this order.
Mr. Speaker, if I may be guided.
Who is supposed to allow you? Is it not the Speaker?
The Speaker allowed
so
me.
If they say Speaker may allow you, is it an obligation on the Speaker?
Mr. Speaker, may I be allowed to ask a second supplementary question?
Honourable members, let's take note. It's at the discretion of the Speaker. This is what the order clearly is saying. So, please, you have the floor.
Most grateful, Right Honourable Speaker. Mr. Speaker, I want to find out from the Minister of Justice and Attorney General, from the 4th paragraph, where he indicated that the 2nd, 4th, and 5th accused persons, no cogent evidence were established to prove their involvement in the robbery. Consequently, no charges were preferred against them. I'm wondering why we still have the Republic prosecuting 1st to 5th accused when those 3 people had no cogent evidence against them in the matter. Thank you very much, Right Honourable Speaker.
Yes, Honourable Minister. The question is, no evidence to prosecute some people. Why are others being prosecuted?
Mr. Speaker, whenever, as the prosecution, we come to the conclusion that there is no cogent evidence to prosecute anybody, we drop the charges. That is precisely the point that I am making. That once we have not found cogent evidence in the course of the investigation, we drop the charges. So that's the point that I am making.
No, Honourable Member, then it follows that for the others that are being prosecuted, there are cogent evidence against them. That is why they are being prosecuted. Yes, Honourable Kwame Anyumedo-Benchi, you have the floor.
All right, thank you, Mr. Speaker. Mr. Speaker, I think the supporting staff are making the Attorney General's work difficult. The background that the minister gives, we have the 1st, 2nd, 3rd, 4th, and 5th accused persons. Once they are accused persons, it means that they have been accused. And, Mr. Speaker, the 1st and 2nd accused persons, we are told that they admitted to the police having committed the offense. But we have the minister on record saying that the 1st and 3rd accused persons are prosecuted. We didn't hear what had happened to the 2nd accused person. Why are their names still part of the accused persons? I do not get it. And following from the last person that asked the supplementary question, if you have them as accused persons, then they have been accused. So I do not understand. There isn't. I don't get the coherence here, Honorable Attorney General. So if you have accused them all, did you listen to what the confession statement from the police and use that, or you are not using that? Thank you, Mr. Speaker.
Yes, Honorable Minister.
Right, Honorable Speaker. The Honorable Kwame Imedu is a very senior legal practitioner in this republic. When a docket is prepared, usually all persons named as suspects are listed. And in fact, sometimes the police will prepare preliminary charges that will be brought to the AG's department. It is when we have evaluated the document and the docket and come to the conclusion that the person should not be charged, that person will be dropped, from the charge sheet. Now, during the committal proceedings, all of them were named as accused persons. But subsequently, upon further interrogation of the docket and investigation, we decided to drop, the persons who were not in respect of whom we could not find cogent evidence. That is the state of affairs now. Thank you, Right Honorable Speaker.
Honourable members, can we move to question number 48, standing in the name of Honourable John Dako, Member of Parliament for Swami.
Mr. Speaker, with respect, I rise to ask the Minister for Justice and Attorney General the effort being made, the Minister for Justice and Attorney General to provide the memorandum which formed the basis for the decision to withdraw the charges against Dr. John Pandit Esiama.
Yes, Honourable Minister.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, after consideration of the request by the member, it is the view of the Attorney General's office that the information requested cannot be provided as the information requested falls under the exempt information under the Right to Information Act 2019, Act 989. Mr. Speaker, Act 989 in its long title indicates that it was passed to provide for the implementation of the constitutional right to information held by a public institution subject to statutory exemptions. Accordingly, it is significant whether the request is made pursuant to Act 989 or not. The Act provides several instances in which requests may be refused if the information requested is exempt. In terms of Section 13(1) of Act 989, it states as follows: information is exempt from disclosure where the disclosure of the information will reveal A, an opinion or an advice given, or a recommendation, consultation, or deliberation made to a public institution and is likely to undermine the deliberative process the deliberative process in that public institution. Mr. Speaker, the information as requested by the Honourable Member seeks to access a memo from the Prosecutions Division to the former AG on a case prosecuted by the Prosecutions Division. The correspondence referred to constitutes the legal opinion on the case given by the Prosecutions Division to the former Attorney General. The request would most likely, as is normally done, be for the review and approval of the former Attorney General. That being the case, it amounts to an opinion as stated under Section 13(1) of the Right to Information Act and is thus exempt from disclosure to the honorable member. Additionally, several subsections of Section 7 of Act 989 would also apply in this instance to exempt the information requested, as the information would contain confidential sources of information relating to law enforcement and public safety that would affect and impede the prosecution of the cases. Thank you, Mr. Speaker.
Thank you, Honourable Member. Any supplementary question?
Yes, thank you, Right Honourable Speaker. Minister, from your answer, you have referred to the former Attorney General of Ghana. The third former Attorney General has come out to deny the existence of the third memo. So I suggest that you provide the memo to dispel that particular claim, to say that you don't have
Honourable
to
Member,
disclose.
Honourable Member, I think your question was very clear. To ask the Attorney General and Minister for Justice to provide the memorandum which formed the basis for the decision to withdraw the charges against Dr. John Paddy, Siama. And the Attorney General in the answer is telling you that it's a classified information. So once it is a classified information, it cannot be provided no matter the circumstances. So what is your question?
Thank you, Right Honourable Speaker. Now, to say that it's a classified information is to suggest that it exists. He referred to the former minister who says that no such memoranda exists. No, so he says it doesn't exist. So how do you say it exists?
Honourable John Dako.
Yes, Mr. Speaker.
Once it is a classified information, does it matter whether it exists or does not exist?
Thank you, Mr. Speaker. If it doesn't exist, it cannot be classified. So it must exist.
Regarding the production.
No.
Regarding the production.
So that's what I'm saying, that the former minister has come out to say that in his time, no such memorandum
That is where I have the problem with you.
What is the problem,
because
Mr. Speaker?
of the former minister that you are bringing in. The question is directed at this minister to produce a document. And he is telling you that the document you are asking him to produce is a classified information.
So, Mr. Speaker, with respect, it means that that document exists. Yeah, but the former minister has come out clearly, severally, to deny the existence of that memorandum. So if it doesn't exist, how do you classify it?
Can you produce evidence of the former minister denying?
Mr. Speaker, with
because
respect,
for
Mr.
me,
Speaker, with respect,
the answers that I have listened to and from the question, I haven't seen anything of that nature. So when I look at it in line with Order 89, I have a problem with your question.
Mr. Speaker, with respect, if we go to the particular act he is referring to, the Learned Attorney General is referring to, the Act 989, he made reference to 13.1, but in the same act, 13.2, it provides that information which merely contains material that has been publicly mentioned as the basis of a public policy or for formulating a public opinion, or contains only factual or statistical data, is not exempt from disclosure. And so, if that document exists, it will not be exempt from disclosure by reason of Section 13.2.
So you think this is on statistical data?
Mr. Speaker, I read a lot. I read A before I came to B. The A says that merely contains
question
material
overruled.
that has
Do you
been
have another question?
mentioned.
Question overruled. Do you have another question?
As in the first question is overruled. So
yes.
as you ask the second question.
Yes.
Mr. Minister, the memorandum in question, did you cite it in your department?
Yes, Honourable Minister.
Right Honourable Speaker, it appears the honorable member is choosing, for reasons that I won't blame him for, to believe the former Minister of Justice and Attorney General over myself as the current occupant of that office. In fact, as a matter of internal policy, that document you are referring to, the memorandum, did come to me in the form of an email from the Director of Public Prosecutions. And it was based upon her advice. And that is why we are saying that the document you are asking me to produce today is opinion that was meant to advise the Attorney General to take a decision. And that is statutorily exempt under the Right to Information Act. In any case, Mr. Speaker, a member of Parliament cannot summon a minister to say a minister should produce a document. Basically, what you are asking me to do today is to produce a document. That power is only granted under the Constitution to committees of Parliament and Parliament as a whole. For a member, if you are asking for the production of a document, it will be in relation to the content of the document and not the production of the document per se. And I have explained that that memo came to the former Attorney General and also came to me, based upon which I took the decision that I took.
Right Honorable Speaker.
Honourable Member, you may also apprise yourself by looking at Article 103.
Yes.
Yes.
Yes. So, Mr. Minister, I really want to understand, is it your case now then that a member of Parliament cannot ask a minister to provide documents for statement he's made? Is that your case with this House right now?
You see, that is why I'm asking you to look at Article 103. It's clear on the issue. Members, let me take Article 1036. A committee appointed under this article shall have the powers, rights, and privileges of High Court or Justice of the High Court at a trial for enforcing the attendance of a witness and examining them on oath, affirmation, or otherwise. B, compelling the production of a document. C, issuing a commission or a request to examine witness abroad. And it's a committee appointed. So, honourable members, I hear some members of Parliament saying, I have a power of the High Court. No, that's not the case.
Right Honorable Speaker, I understand, but I'm sure you also agree with me that this House operates with both the Constitution and the standing orders. And the standing orders obviously allow a member of Parliament to ask the minister's question. And so this came in the form of a question. And I believe
you see, Honorable John Dako, you are getting this out of context. It is not just a question that you are asking, but your question is about production of a document. And the article that we have read doesn't suggest that a member of Parliament cannot ask questions. But the right to request for a document to be produced, Constitution has vested it in committees. That is all that we are saying. And you are a lawyer, you look at the provision clearly. It says a committee.
Yeah, Mr. Speaker, thank you very much. And I believe that the minister saw the question as a necessary question That is why he provided the information. So if his position is that the document exists but he cannot provide that document, then I rest my case. Thank you, Right Honorable Speaker.
Thank you. Yes, Honorable Roxanne Nelson.
Speaker.
Kwame Eche Dafamako.
Speaker, John and I go way back. In fact, my roommate in law school. It is not the minister saying he cannot provide. He says the law forbids him. And he has spoken eloquently to the matter. So creating the impression that the minister says the document exists but he cannot provide, that is not the rendition. He says it exists, but I'm forbidden by this House's own enactment. It's exempted. He's quoted it in the... Please, the right to information here provides. It's an opinion. So we are lawmakers, and luckily we are also lawyers. So we should be guided. If he wants to use his committee to do this, it's mandated under law.
Honourable members, I was instrumental in the passage of the Right to Information Act, so I know that some informations are classified. And the minister in his answer quoted the various provisions that classified the information. Yes, Minority Leader.
Mr. Speaker, with respect, if care is not taken, we may be setting a very troubling precedent, all in the name of the law. All in the name of the law. What is the gravamen of the question? Minister is arguing certain exemptions under the law to suggest that he cannot provide because RTI stops him from providing that information. Mr. Speaker, for the avoidance of doubt, and I would urge patience as we all navigate this matter, because it's not for today. Whatever we're saying now for Hansard may be a reference point tomorrow. And I'm not disturbed at all when Speaker rules for or against. What is the member saying? Listen, to ask the Attorney General and Minister for Justice to provide the memorandum which formed the basis for the decision to withdraw charges against Dr. John Pandit Isiama. Mr. Speaker, a Minister of State has taken a decision on the basis of advice. We all know that, of course, nolle prosequi interest matter, resulting in a member of Parliament asking you to provide that information. At least it helps you and your image and that of the government that the basis upon which you filed the nolle prosequi was well founded. If you now say that by a certain enactment, the member of Parliament must file for some disclosure under RTI or that, and that by this act, House's own enactment, he is forbidden or he is stopped from providing the information. Mr. Speaker, I find it very rich. I find it very rich.
Honorable
That is an unfortunate.
Honorable Minority Leader.
Mr. Speaker, if I may conclude with respect.
But with all due respect, you and I were here and we took part in the passage of the law.
That is so.
Now, does the law says in classifying the information that based on public interest, the information should be provided? If no, then I believe we should proceed to another question.
Mr. Speaker, this exercise is good for all of us. Mr. Speaker, who determines, honorable member for Isikado, you are coming
Please
from
address the chair.
Okay, Mr. Speaker, I want my respected junior colleague to know that she shouldn't come to the front bench to be talking across, please. Mr. Speaker, who is determining that this piece of advice, the basis for this decision by the Attorney General, is classified? Is he the one who is saying that it is classified, or the law is saying
the law?
That when, Mr. Speaker, I need to finish. Mr. Speaker, Mr. Speaker, I have had my time at the bar. Mr. Speaker, I have had my time at the bar, and I'm able to make my argument. I have to be heard, and if you disagree, you rule against me. The interjections are getting out of hand. Mr. Speaker, if the law is saying that any primary document, the subject matter of a final decision making, is classified, the law must expressly say so. Mr. Speaker, if the Attorney General, the first gentleman of the bar, a citizen is facing prosecution, and he comes in to say that no, I'm withdrawing charges, and he says that it is not me, but I have been advised, and it's not me. The Attorney General is not saying that he himself.
Attorney General, I'll give you the floor.
But he
so
says that
just hold it.
the Attorney General is saying that he's been advised, because, Mr. Speaker, the government of the question tells it all. That says that provide the memorandum. Mr. Speaker, the fact that there is a memorandum is a matter of subject public knowledge. The Attorney General's office put out in the public domain that there was a memorandum, that it is based on the memorandum that he has exercised discretion. The questioner is therefore asking you, make available to the people's representatives this memorandum, and you say it's classified, it's a secret document, it's very rich. He will not use any available other tool. The tool available to him is what he's using to say that make available that memorandum for all of us to see. Peruse it. Mr. Speaker, I so submit, and I believe that the member must be allowed to ask his question, and that minister cannot hide under any law to say he won't give the details of this memorandum.
Honorable Minority Leader, I would have a problem when you say the member is not allowed to ask questions. The member has been given the opportunity to ask the question. Now the minister has provided answers to those questions. Then the member had the opportunity of even asking supplementary questions. You see, Honorable John Dako, with all due respect, we are not in Makola. We are in Parliament. You cannot just shout across like that. You cannot just shout across like that. So the minister has provided the answers. So when the answers are provided, the minister quoted the right law to say that this particular information is a classified information. So once a classified information, now the minister also went further to say that the circumstances based on which you can be compelled to produce documents are spelled out in Article 103. And I even took the trouble to read Article 103, specifically 6. So I have a difficulty getting the tangent from which you are coming from. Yes, Whip.
Speaker, the minister appropriately referenced the RTI Act. And the minority leader is suggesting that requirement be set aside. He says, he actually says so, that we shouldn't do this within the law. But that cannot be. Because
remember, that is why I'm asking him that the
Speaker,
Right Information Act
Speaker,
that
RT
we all
actually
pass,
classifies.
does it set out the circumstances of that nature?
Speaker, under Section 84, the interpretation section of RTI Act, it defines Speaker, it defines state secret as follows. Includes information considered confidential by the government, which, if disclosed, will be prejudicial to the security of the state or injurious to the public interest, and it proceeds. Mr. Speaker, in the answer provided by the minister, he referenced that the information as requested by the applicant seeks access to a memo from the prosecutions division to the former AG on a case prosecuted by the prosecutions division. The correspondence refers to constitute the legal opinion on the case given by the prosecutions division to the former AG. The request will most likely, as normally done, be for the review and approval of the former AG. This is an opinion, and this is classified under the Exempt Act, properly defined as a state secret. So for the minority leader to actually suggest that we should set all these requirements under law aside and play to the public gallery is actually saying that we shouldn't rule this house by rule of law. We should rule by the opinion of the masses out there. And that will be chaotic. It will be leading us into a path that clearly will
yes,
create
honorable,
so,
honorable members, in the absence of any supplementary question.
Yeah. Very
Yes.
respectfully.
Yes.
Speaker, this is a very important matter.
Do you have a supplementary question?
Speaker, I have a supplementary question.
So please proceed to ask the supplementary question within the meaning
Honorable
of Order
Attorney
89.
General, Honorable Attorney General, given that the instant request by the Honorable Member of Parliament was not made under the RTI Act, but under the Constitution of the Republic of Ghana, the Constitution gives every Member of Parliament to ask questions as under our standing orders. You ask questions in performance of your oversight responsibility. To the extent that the question that came was not under the RTI Act, but in performance of the member's oversight responsibility, do you think that you can exclude it under the RTI Act? Do you think that you can exclude? Do you think that you can exclude it under the RTI Act, especially taking into account the fact that the RTI Act cannot exclude the performance of a legislative duty under the Constitution? Do you think you can do that?
So before giving the floor to the Honorable Minister to explain, Honorable Member Questioner, do you think if an information is classified under the right to information, when you are proceeding not under the right to information, the information should be given out?
Thank you very much. Mr. Speaker, you asked me.
Very well. Minister,
Mr. Speaker,
you have the floor.
I think that the RTI Act is not relevant in the circumstance. First and foremost, Mr. Speaker, the duty we perform on the floor of this House, Mr. Speaker, under Article 93 of the Constitution and other provisions, Mr. Speaker, that flows there from, Mr. Speaker, are legislative duties. The RTI Act, Mr. Speaker, under Section 1 is clear as to its relevance. Mr. Speaker, when a member of Parliament is performing that and every minister will come to this floor and say that every information we seek is confidential. It is a very dangerous part, Mr. Speaker.
Honorable
very
Member,
dangerous
I
part.
believe in constitutional jurisprudence. You mentioned Article 93. Article 93 says there shall be Parliament of Ghana which shall consist of not less than 140 elected members. 2, subject to the provisions of this Constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution. What has this got to do with the legislative power?
Mr. Speaker, Mr. Speaker, Mr. Speaker, Mr. Speaker, I said, Mr. Speaker, I said 93 and other provisions. Mr. Speaker, it is very important we appreciate. Mr. Speaker, it's important we appreciate that in interpreting the Constitution, you interpret it as a whole, not in isolation, with every part giving harmony to each provision. Mr. Speaker, if you go on this tangent, this House is in trouble.
Kindly resume your seat. That is why in quoting 93, I didn't quote 93.1 and leave 93.2. I have read the 93 in a whole. I've read the 93 as a whole document. Yes, Honorable Minister, Speaker, you may wind up. I think we should move to another question.
Right Honorable Speaker. Right Honorable Speaker, may the minority leader give me his ear. Right Honorable Speaker, I am supremely surprised that the Honorable Darko, being the lawyer that he is saying that a statute duly enacted by this House for purposes of the implementation of a constitutional provision should be set aside in the interest of so-called performance of legislative duties. In fact, no, this is very important. We enacted the Right to Information Act, and we saw it fit and proper in the implementation of the right to information under Article 21 of the Constitution to say that certain aspects of public information may be exempted from disclosure. And Section 13 of the Act, 13.1, is specific that opinions, expressed in the normal course of the performance of the duties of a ministry, department, or agency of government is exempt from disclosure. Despite the fact that when the honorable member made the request, there was no reference to the Right to Information Act. There was no reference to the Right to Information Act. But I can say, Mr. Speaker, that this was a public disclosure, in all its dimensions. And in fact, I was asked to provide the memorandum. I was not asked to disclose the content of the memorandum. There's a well of difference between the two. Production of documents is a different matter altogether from from disclosure of the information. And the disclosure of the information is what is regulated by the RTI. When it comes to the production of documents, under Article 103(6) of the Constitution, it is only committees of Parliament that are vested with the power to compel the production of documents. And that is why I told the honorable member that if he's asking that we should produce the document, he does not have that power as a single member of this House to compel the Attorney General to produce that document. In any case, the opinion was provided by the DPP, that is the Director of Public Prosecutions, to the former Attorney General, and government is a continuum. Based upon that opinion which was expressed, I took the decision and I took ownership of that decision. I took responsibility. So contrary to the assertion by the honorable minority leader that I took that decision because of the memorandum, and therefore I wasn't the one who took the decision. I took the decision, and I take responsibility for it. But in justifying the taking of the decision, I refer to the memorandum, and I can tell you in all honesty, and I'm acting with integrity before this House, that memorandum is in existence, but it is exempt under the Right to Information Act. I thank you very much, Mr. Speaker.
Thank you very much. Honorable member, please kindly resume your seat because you had the opportunity to ask your two questions. Please, minority leader. Honorable members, we are at a stage that we're supposed to ask supplementary question. If it is not a supplementary question, please, I would even overrule you before you wind up. Yes, let me take Minority Leader first. Supplementary question.
Mr. Speaker, before going into the supplementary question, I believe that the learned Attorney General took to the dispatch box, and although you had ruled on the question, he took the opportunity to express an opinion on the matter. If you would permit me, I would want to express a view. First of all, Mr. Speaker, he misconstrued the submissions made by me earlier. And Mr. Speaker, he is the one who put out this issue of memorandum. He said that he relied on the advice of the DPP as contained in the memorandum to take a decision. My issue is this. To the extent that in taking
Honorable
this decision,
Minority Leader, I think that is not a supplementary question. So,
Mr. Speaker, yes,
with all
Mr.
due,
Speaker, I didn't say
with
I was
all
asking
due
a
respect,
supplementary question.
please
Mr. Speaker,
kindly resume your seat. With
Mr.
all
Speaker,
due respect,
Mr.
let me
Speaker,
hear from Honorable
conclude.
Majority
Mr.
Leader.
Speaker, Mr. Speaker,
Honorable
please,
Minority
Mr. Speaker,
Leader,
bear
please, with
me.
all due respect,
Mr. Speaker, I
kindly
get you,
resume
Mr.
your
Speaker.
seat.
Bear with me.
Let me hear from
Leader.
Honorable Majority Leader. Honorable Majority Leader, you have the floor.
Mr. Speaker,
Honorable Majority Leader, you have the floor. Honorable Minority Leader, kindly resume your seat.
Mr. Speaker.
With all due respect, kindly resume
Mr.
your
Speaker,
seat.
I shall yield to you.
Very well. Honorable Majority Leader.
The Minister for Justice and Attorney General, you indicated in your answer that you relied on a memorandum. I want to ask the Minister if, in the exercise of his discretion to enter a nolle prosequi, whether he is obliged to explain at all.
Yes, Honorable Minority Leader. Honorable Minister.
Yeah, by law, Mr. Speaker, by law, I'm not obliged to explain my decision to enter a nolle prosequi. But in situations where, or even in situations where I terminate the case after the prosecution has ended its, has ended its case, I am not obliged to explain the reasons why I have terminated the matter. And so on both counts, whether it was a nolle prosequi or it was a termination, I am not obliged to explain.
Yes, Honorable Minority Leader.
Honorable Attorney General, would you agree with me that to the extent that you volunteered to make a disclosure of the existence of a memorandum giving rise to your decision to terminate the prosecution, you are obliged under Article 23 of the Constitution to act fairly by way of ensuring a full disclosure in the public interest, because you have brought the matter up to the public knowledge. You were not obliged to make any disclosure, as you said.
Honorable Minority Leader, with all due respect, together let's look at Order 88.7. With all due respect.
Very well.
It states that a member in asking question, Order 88.7.
Mr. Speaker,
a member in asking question
Mr. Speaker,
shall not address the House, raise any argument, or offer an opinion.
Okay.
So let's operate within the rules.
Very well. Mr. Speaker, very well. Very well. Honorable Attorney General, it is your case that by law, you are not obliged to explain why you've entered nolle prosequi. But you are on record to have made a disclosure to the public regarding the existence of a memorandum giving rise to your decision. Wouldn't you, under the circumstance, be obliged to comply with Article 23 of the Constitution?
Honourable Minister, you have the floor.
Right, Honourable Speaker. Article 23 is on administrative authorities, and it obliges administrative authorities to act fairly and reasonably and comply and be candid and comply with the requirements imposed by law. Right, Honourable Speaker, this afternoon I acted fairly and candidly, and I complied with the RTI Act in my answer. So I have complied with Article 23, and in any case, I was exercising executive authority and not administrative authority. Thank you.
Mr.
Yes,
Speaker.
Honourable Minority Leader.
Thank you. Mr. Speaker, in view of the Minister's answer, may I know from him, having regard to his own disclosure to this House, that he decided to enter a nolle prosequi for ordinary language, in ordinary language, that there was prosecution of Dr. Isiama, and he said that he is no more interested in the prosecution. And he was not obliged to explain to the public why he has stopped the prosecution, but he explained. Would he say that that decision complied with Article 296 of the Constitution?
Yes, Honourable Minister.
Mr. Speaker, the minority leader, that will be in 30 years' time. The minority leader is shifting goalposts. First of all, he tried to pin me down in respect of Article 23 and failed in that effort. Now he's asking if I complied with Article 296 on the exercise of discretion. In fact, within the context of Article 296, I acted, in a manner that was non-arbitrary. Okay? In the sense that I took the decision and I counted to the people of this country. And in fact, I even quoted portions of the advice that was in line with the letter and spirit of Article 296. What the minority is seeking to achieve, now, and let us face it, this is politics. What the minority is seeking to achieve now is basically to vindicate the former Attorney General, who denied the existence of the memo. But if you talk to the staff who were involved in the work, they will affirm or confirm that that memo was authored, that it was on the basis of the memo and the discussions I held with them that I took the decision, which is the subject matter of the member's question. In any case, Right Honourable Speaker, the member is not asking for a disclosure of the information on the memo. He's asking for a production of the document. And that is because the former Attorney General publicly said that that memo did not exist. And so you are seeking to vindicate him in the sense that the memo did not exist. But I can confirm that the memo exists. No. Production of the document, I have come under RTI, to say that the document is exempt, we are complying with the law that was enacted by this House. So we, as lawmakers, enacted a law. We should be the first people to comply with the tenets of the law. Because as Right Honorable Speaker likes saying, quoting the German philosopher Habermas, law is communicative action. And if we have communicated the principles of the RTI law to the public, to the populace, we should be the first people to comply with it. So I have complied with the RTI law. I have complied with Article 23 of the Constitution. I have also complied with Article 296 of the Constitution. Thank you, Right Honorable Speaker.
Minority Leader, if I heard you well, you say this is your last question. After last question, do you ask another last question
Mr.
again?
Speaker, the respected learned Attorney General, taking his time at the dispatch box, argues in his submission that he made some disclosure of that advice in his public accountability engagement. In other words, one of the press conferences that he himself held, according to him...
Minority Leader, I have read Order 88.7 to you.
Yes, Mr. Speaker, I'm not saying anything
does
new.
not allow you to
very
do
well.
what
Mr.
you
Speaker,
are
I get
doing.
it. Mr.
So
Speaker,
you are
I get
either going to ask the question
Mr. Speaker, I get
or I overrule you.
Mr. Speaker, I get the point you want to make. I shall assist the chair. Mr. Speaker, the learned Attorney General has disclosed to us that he has already made available aspects of the memo to the public. Would he make that disclosure before Parliament? Those details that he disclosed to the public, according to him, would he make that same disclosure here?
Yes, Honorable Minister.
Mr. Speaker, the press conference that I delivered on that fateful day when I mentioned or I made reference to the memo, I quoted portions of the memo, and that is already a public document. And so I think that that document, the press conference, can be made available to the Minority Leader and his members if they want.
Mr. Speaker, with the greatest respect. Mr. Speaker, with the greatest respect, this is House of Parliament. If a Minister of State before Parliament and at the dispatch box says that he has made some disclosures, and we say repeat them for the purpose of Hansard, then you can say you produce them later for Hansard. It is not for private consumption. The information is for Hansard. Mr. Speaker, may he state his position correctly. Is he saying that he will make it available for Hansard?
Minority Leader, let's look at it practically.
Very well.
We've all engaged in press conference. So if you have done a press conference and some days or months after, you are being called upon to be by the dispatch box to state what is contained in the press conference.
Mr. Speaker, we can solve it this way. Mr. Speaker, don't worry. I'm always amenable. This matter, you don't drag it. He says he will make the document available. Can he? Yes, he says he will make the press conference available.
Mr. Speaker, he even indicated that Mr. Speaker, it is now a public document.
Very well, he should make it available for Hansard, so that we'll take it from.
Well, I intend not to give such orders that he should make it available now. Honorable Ayarga, you have the floor.
I was just going to say that, Mr. Speaker, that question is unrelated to the question. The question is about memorandum. That question is about a memorandum. But this one is talking about a press conference statement. Oh. Mr. Speaker, the minority leader just confirmed to everybody in this chamber that he's a master of mischief. That he is a master of mischief.
Yes, I've heard him that
mischief.
you don't know how to do mischief.
I don't know how to do mischief.
With all due respect, we have taken too much time on this question. I intend not to allow any further question. I proceed to question number 120, standing in the name of Mr. Anthony Mie, Odotobri, Member of Parliament. You have the floor.
Thank you, Right Honorable Speaker. I rise to ask the Minister for Justice and Attorney General the efforts being made to finalize the legislative instrument, which is to regulate the operation of the Lands Act, Act 1036, for same to be presented to Parliament for consideration and passage.
Yes, Honorable Minister.
Thank you, Right Honorable Speaker. Right Honorable Speaker, by a correspondence with reference number DB 134/135/01, dated 15 July 2024, the Ministry of Lands and Natural Resources, that is the sponsor of the land regulations, submitted drafting instructions on the land regulations to the Office of the Attorney General and Ministry of Justice for vetting. The correspondence was received on July 18, 2024 at the Office of the Attorney General and Ministry of Justice. By a correspondence with reference number SI 19/2024, dated 23 July 2024, the Office of the Attorney General and Ministry of Justice requested a sponsor for an electronic copy of the drafting instructions to facilitate work on the regulations. On receipt of the electronic copy of the drafting instructions, the Office of the Attorney General and Ministry of Justice proceeded to vet the drafting instructions, and by a correspondence with reference number SI 19/2024, dated 21st October 2024, submitted the draft regulations and comments on the draft regulations to the sponsor. The sponsor was requested to respond to the comments and to communicate any further comments the sponsor may have on the draft regulations to enable the Office of the Attorney General and Ministry of Justice to finalize the work on the draft regulations. Mr. Speaker, however, by correspondence with reference number DB 134/135/01, dated 28 February 2025, the sponsor submitted to the Office of the Attorney General and Ministry of Justice new drafting instructions on the land regulations and responses to comments on the draft land regulations. The responses use the new drafting instructions as the source document. The new drafting instructions were a revision of the draft regulations and incorporation of new draft legislative proposals. To facilitate work on the drafting instructions, the Office of the Attorney General, by correspondence with reference number SI 19/2024, dated 24th of March 2025, requested the sponsor to respond to the comments with reference to the draft regulations prepared by the Office of Attorney General and Ministry of Justice and submitted to the sponsor under cover of correspondence dated 21st October 2024. In addition to any new legislative proposals they may have to the Office of the Attorney General and Ministry of Justice in a separate document. This point was reiterated at a meeting held on 16th April 2025 between the officers of the Lands Commission and an attorney of the Office of the Attorney General. Further to the correspondence with reference number SI 19/2024, dated 24th March 2025, and the meeting held on the 16th of April 2025, the sponsor has by correspondence with reference number SCR/LCS 830/17, dated 17th April 2025, responded accordingly to the request. The correspondence was received by the Office of the Attorney General and Minister of Justice on 13th May 2025. The sponsor has provided responses to the comments on the draft land regulations and submitted new legislative proposals for a revision of the draft land regulations. The Office of the Attorney General and Minister of Justice has revised the draft regulations to incorporate the responses to the comments raised and the new legislative proposals into the draft regulations and submitted it by correspondence dated 9th June 2025 for the consideration of the sponsor. Further to the expression of satisfaction by the sponsor with the regulations, the Office of the Attorney General and Minister of Justice will finalize and submit the regulations to the sponsor, and in accordance with the enactment process, request the sponsor to liaise with the clerk to the Parliamentary Committee on Subsidiary Legislation to arrange for a pre-laying meeting for the Parliamentary Committee on Subsidiary Legislation to consider the regulations before the regulations are laid in Parliament for the statutory 21 sitting days in accordance with Article 11(7) of the Constitution of the Republic of Ghana. I thank you very much, Mr. Speaker.
Honourable Member, any supplementary?
There will be no further questions. I am very grateful, Minister. I'm also grateful to the Right Honourable Speaker.
Thank you very much. Yes, Honourable Jerry Ahmed Shaib.
Very well, Right Honourable Speaker. Thank you very much for the opportunity. Just to find out from the Honourable Attorney General if he has any timelines to the effect with reference to the response he just gave.
But Honourable Jerry, actually he is not the sponsor. The sponsor will be the Minister for Lands and Natural Resources. So they are just providing legal services, which the answer has indicated. So if there is a minister that should be providing a timeline, there should be a minister responsible for lands and natural resources.
Very well, Right Honourable Speaker. I do not know if I can proceed to ask a further question. Subject to...
Yes, please do.
Yeah, I just want to find out when he hopes to transmit the advice to the Ministry of Lands and Natural Resources.
Well, let me give the chance to the minister. But the answer clearly has been given. That has been transmitted on the 9th.
On the 9th
of June.
That is just two days ago. No, a day ago.
Yes.
That's Monday. Yes. Yeah, I've sent the advice to the Minister of Lands and Natural Resources.
Mr. Speaker, in view of the fact that this is a major public interest matter, the fact that, Mr. Speaker, the activities on our water bodies, on our forest reserves, have become of grave concern to the country. Would the Attorney General ensure that, having transmitted this opinion, his assigned officers at the Lands Ministry will facilitate the drafting of this legislative instrument to this House without further delay?
Honourable members, respectfully, I stand on Standing Order 89 to overrule the question. Is there any other question? Yes, Majority Leader, any indication?
Mr. Speaker, I think that is it for questions.
Very well. Then, if that's the case, let me discharge the Attorney General. Attorney General, thank you very much for attending upon the House and answering the questions slated for you. We are most grateful. for answering the question to the satisfaction of the members of Parliament. You are hereby discharged.
Mr. Speaker, with respect, when you are presiding, you don't pass judgment to the extent that we are satisfied with his answers. Mr. Speaker, we are not satisfied with his answers. He gave political answers and we are not satisfied with his answers.
Well, Honorable Habib, the Speaker looking at the atmosphere is just expressing an opinion. So my opinion is that members are satisfied with the answers provided. Yes, Majority Leader. Now, indication.
The Honorable Ranking, please. It's been admitted, please. Mr. Speaker himself has admitted. Mr. Speaker, the Honorable Ranking has been sitting since we started to take his statement, which you admitted. Mr. Speaker, he's now ready to take his statement. Yeah, Mr. Speaker, he's ready to take his statement if you grant him the leave.
Honourable members, by the rules, when statements are admitted, they are supposed to be transmitted to the clerk and they program the statement. Honourable members, this issue of statement being handed over there and then, and you are expected to admit it, is not helping all of us. So, appropriately, I will indicate and transmit the statement to the clerk that please, the statement has been admitted. Kindly program it to be taken.
Mr. Speaker, with respect, look, your leader is seated. Please take your seat. If for nothing at all, he is the one to rise on any rebuttal. You sit down. You are a junior, so sit down. Sit down. You sit down. This is leader. You are in the ship. You are not a leader. You are in the ship. This is leader to leader. Sit down. Mr. Speaker, I made a humble application to you. Mr. Speaker, there is an important matter that we all know is happening in our country. The minority through its ranking brought this statement to you. Mr. Speaker, it is so critical, a statement that will help all of us as Ghanaians. Mr. Speaker, I would plead with you that kindly grant him leave to proceed to make a statement. Mr. Speaker, please, there are other statements. That one I won't press it. But the one on the health issues, the nurses, Mr. Speaker, I will plead with you. It's something that all of us want to have a bite on for the good of our country. Mr. Speaker, so I'm pleading with you. Mr. Speaker, it's a humble plea. I'm not asking for the other statement you admitted. It's in respect of Dr. Ayuwefriye and Honorable Jerry Ahmed. Mr. Speaker, Jerry is in leadership. Honorable Majority Leader, I saw you shaking your head. Don't do this. The Parliament is for the minority. You've been in minority before. You've been on this side before. You've been on this side before. I saw you. I've been in that cell before.
We saw.
I saw you.
We can reverse it.
You see, please. Let's allow him to make his statement. I expect you to be the
Honorable
one.
Minority Leader, you know me.
Mr. Speaker,
Honesty is the best policy. Honorable members, as I walk into the chamber, 3 statements were referred to me. One standing in the name of the Minority Leader, another one standing in the name of Honorable Stephen Amwa, another one standing in the name of Honorable Patricia Apiaje. I have admitted all to be programmed by the clerk. Then the Deputy Whip also brought a statement. But honestly speaking, I was unable to read through his statement to even take a decision whether to admit or not to admit. But I'm being called upon to call the statement. That's the difficulty that I have. That's the difficulty that I have. So the admitted statement for today are to be programmed by the clerk. So if I'm not being given the opportunity to read through the statement and take a decision, then I am also operating contrary to the rules. Yes, Majority Leader. Honorable Habib, still on statement.
Yes, Mr. Speaker, I just want to draw your attention to section of Order 93.1. Order 93.1 up to 8. Mr. Speaker, like you indicated, the person or the member to make the statement have not offended our rules in any way. If there is one way or the other, either the clerk at table have not been able to program his statement, that is not his fault, because statement has been advertised on the order paper today. So it did not offend under Order 93.7. Mr. Speaker, it says that the Speaker shall cause to be transmitted to the clerk statement admitted to be made on a particular day to be advertised on the order paper for the purpose of the notice of members. Mr. Speaker, that has been complied. That if you look at today's order paper, page 3, 9, item 9, we have statements. So, Mr. Speaker, if the clerk at table did not have statement admitted, and for that matter, statement to be read today, there's no reason for it finding its space under the order paper. So, Mr. Speaker, as such, I invite you to indulge the member to make such statements.
Honorable member, I think we are speaking at cross purpose. Read Order 93.2. It states, the proposed statement shall be admitted by the Speaker with or without modification. Now, whilst I am in the chamber, a statement has been given to me to admit, and I couldn't read the statement. How would I transmit this statement to the clerk with or without modification? So the point that I'm making is that when I walk in, I receive 3 statements which I quickly read through and admitted them to be programmed by the clerk. Then my very good friend and classmate brought his statement. But you can see that his statement I have not read through, so I have not indicated anything. But because I have read the majority leader's statement, I have admitted it to be forwarded to the clerk. Because I have read the statement of Honorable Patricia Apiaje, I have admitted it to be programmed by the clerk. I have read the statement by Honorable Stephen Amwa, whilst in the chamber. I have admitted it to be transmitted. But because Speaker called me to take the chair, I could not read through the statement of my friend Jerry Ahmed. So there is no indication whether it's been admitted or it's not. This is my copy.
Mr. Speaker.
That's the point I'm making.
Mr. Speaker, the able minority leader gave an indication that the member is going to make the statement with regards to the striking nurses. Mr. Speaker, and if you read Order 93.1 properly, it says that, Mr. Speaker, by the indulgence of the House and the leave of a Speaker, a member may explain a matter of personal nature or make a statement on a matter of urgent public importance. Mr. Speaker, people are dying in our hospital as a result of the striking nurses. This is a
Honorable
matter
Habib,
of
kindly resume your seat.
Honorable
Habib, kindly resume your seat. If you want to make an urgent statement taking advantage of Order 93.1 and 67, you ought not to have put it in writing requesting that I should admit or not to admit. Is that the procedure? When your leader has been raising matters of urgent public importance, does he put it into writing? But having written a statement, expecting me to admit it, I would have to read through the statement and decide whether to admit or not to admit. That is the point that I'm making. You have written a statement calling on me to admit the statement. How do I admit a statement without reading through it? If this statement was even to be given to me a day prior to today, you would have been fair to me. I also walk in Parliament, then you give me a statement whilst in Parliament.
Mr. Speaker, I would plead with you to... Mr. Speaker, I would plead with you. I've engaged my colleague. I'm not done. I've engaged my colleague, the majority leader, to oblige this request. Mr. Speaker, he hasn't given me his concurrence. He hasn't told me that he agrees. But Mr. Speaker, though a statement has been forwarded to you, Mr. Speaker, I would again and again plead that since the member intends to invoke Order 93 to bring this to the attention of this House, I humbly plead with you that, Mr. Speaker, let's oblige him. Mr. Speaker, I agree that we must go by our rules, but we've had some rare occasions where we as masters of our own rules have looked at ways of accommodating certain urgent matters for the purposes of democracy. Mr. Speaker, I am pleading with you.
Honorable Minority Leader, you know I'm not a difficult person, but nothing will let me set a bad precedent. Bad precedent in the sense that a member will bring a statement for admission, and there and then the member wants to read the statement. 2, if the member is unable to read the statement, then the member now turns around to say that though I have brought a statement for you to admit, because you didn't admit the statement, let me read the statement under Order 93.1 and 67. The indication is that I intend not to grant any leave.
Yeah, Mr. Speaker, respectfully. Mr. Speaker, respectfully. I'm thinking Order 93.1. There's some moral implication of this reasons why this order is here. Mr. Speaker, matter of urgent public importance. We have clinics closed, people are dying, and we want to share with you why we should talk about this. And at the end of the day, Mr. Speaker, I beg leave of you and with your permission.
Honorable Afriye, kindly resume your seat.
Sit Albert down. Yeah, I would say, you don't understand what you're talking about.
Honorable Habib, I intend not to open any debate on this issue. Yes, Majority Leader.
Mr. Speaker, I think that we can take an adjournment to tomorrow, during which those statements that you have admitted can be made. There's no difference between today and tomorrow, Mr. Speaker.
Yes, honorable members. Motion move for adjournment. Any seconder?
Mr. Speaker, I want to draw your attention to
Honorable
order 3
Habib.
of our standing orders.
Honorable Habib, resume your seat.
Speaker,
motion
I
move
rise
for
to second the
adjournment.
motion.
Any seconder?
Yeah, Mr. Speaker. I rise to second the motion. Yes, I rise to second the motion. In doing so, Mr. Speaker, I make this statement.
Honorable Afriye, if you don't take time, I will send you out of the house.
I'm not worried about that.
Why are you taking liberty
I'm
for
not worried
nonsense?
about that. It's an issue of urgent public importance. I can leave.
In doing so, make one statement.
I can leave. I can leave. I am ready to leave. I am ready to leave.
What do you mean by in doing so, make one statement?
I am ready to leave. You can send me out. I'm ready to leave. That's all this. Yes. I'm ready to leave. What's the big deal?
Honorable members.
Mr. Speaker, we rise to make this statement on an issue of immediate and far-ranging concerns to our country. The ongoing national strike action declared by the
You are hereby directed to walk Afriye out of the house. No, but what is that?
But look, I'll switch on the mic so it will not go.
That's good.
Honourable members, motion moved and seconded. The question is, as many as are in favor of adjournment, say aye. Those against, say no. The ayes have it. The House is adjourned to tomorrow, Wednesday, 11 June 2025 at 2 p.m.
I saw. What do you mean, kind of? Yapon. Close. Go and do press conference. Press conference number 89.
I am sure that even with increased value or reduced pricing, if quality is not improved, we will still have a sour customer experience. This led to the regulator commissioning and completing an assessment of a sample size of network performance in 3G and 4G service offerings across the country, the results of which I discussed with the CEOs and the media 2 weeks ago. In my 4th month, armed with a clear picture of where we are as a sector,